They create patent thickets. They fight every rule, and they sue people who are coming on. And there's just overwhelming evidence that while I'm a strong supporter of the patent system, I'm well aware of the abuse of the patent system. And you said that there are ways which some of these could be worked out. And let me just say to you, let me know what they are, because I want to stop the patent abuses that are out there. Dr. Leonard, I want to go back to you. I thought you made a very good distinction here between something that's naturally occurring and where to do the research that should be available to researchers without having to pay a fee. And you also were on the receiving end of cease and desist, or I guess letters that it stopped research midway. I mean, just respond to this distinction that you're making about how this legislation, in your view, would interfere with innovation in patient care.
So to be clear, I was stopped from doing clinical testing for patients. My research was not stopped. So we had to stop doing 4 tests, the 5th one by Haig Kazazian, who was also at the University of Pennsylvania. I think what is not understood is that as a pathologist, I can develop and validate genetic tests in my clinical laboratory that is CLIA certified and perform that for patients. I don't need a patent. I don't have to license patents because the genes that I'm testing are not patentable now. And that is what will stop. And that every academic laboratory.
Just walk through that very specifically, how that would stop, because
right
that's
now
the heart of this.
We can sequence a baby and parental genomes of a baby in a NICU, just been born and not looking right. And 25% of those patients, babies, we can find a diagnosis that allows for treatment. If not treatment, then stopping a diagnostic
just to interrupt, that has to be done immediately.
Yes. In fact, it's better if it's done prenatally, but it's often done immediately. Imagine 20 to 25,000 genes in the human genome, and if even 1/10 of those are patented, then I have to go get licenses or royalty fees or rights to use that genetic information for my patient. And I became a physician to practice medicine, not to practice law. And that's what it became at the University of Pennsylvania because of genetic sequences that were patented. We didn't need the patents for protection. Companies do. And to go back to Mr. Coons with pancreatic cancer, we now, for the first time at ASCO, an oncology meeting, have a treatment for pancreatic cancer that lengthens life. And it's not as much of a death sentence. It has the opportunity to turn pancreatic cancer into a chronic disease. Innovations are still happening. Therapeutics are being developed. Molecular diagnostic tests are coming on the market. I don't understand the data being cited, that it's being inhibited. Maybe in AI, in other areas, there is a real need, but right now I am not seeing the need in medical practice for basically going backwards.
So literally going back to that NICU example, as a clinician, you would not be able to do what is necessary for the well-being of that baby.
Oh, I might be able to after obtaining 100 or 200 licenses, each at, I mean, the license fees we were charged were $25,000 by one company. We had to pay $120,000 for another.
Yeah.
We ended up having to pay a fee per test for one test that was more than what Medicare reimbursed us for doing that test.
Okay,
If
my time is up, so I'm going to yield back. But thank you very much,
Senator
Dr.
Welch,
Leonard.
the specific exchange that she was referencing, which happened while you were not here, was about this bill having a specific provision that says you cannot patent a human gene. And some of the conditions she's describing were before the Supreme Court ruled you cannot patent a human gene. It's important to put these in a appropriate time context.
Yeah.
Senator Rono.
May I say something in response to the last
Was
exchange?
before me,
We'll
but
get to that in the debate round.
can you clarify for me?
Senator Rono, you are here first, but Senator Blumenthal, would you defer? Or Senator Rono, would you defer to Senator
I'd be happy
Blumenthal?
to defer to
Okay,
my
well-
colleague from Hawaii.
Thank you. I know that patent law is very complicated, and I also know that the Supreme Court and the Mayor and Alice decisions create a lot of uncertainty in the patent system. So I do thank Senators Tillis and Coons for coming up with a bill, which I am a co-sponsor of, that sought to create some level of predictability so that our patent system can be more useful. That's one way of looking at it, I suppose. For Mr. Yanko, you said that the Supreme Court created, or we have an inconsistent framework. Can you just explain why our patent system is an inconsistent framework?
Yes, thank you, Senator. So at least two problems at the high level. First of all, there is a substantive problem, as I mentioned earlier. The courts have taken upon themselves to exclude from patenting whole areas of technology without Congress debating that issue or permitting such exclusions. So that's the substantive problem. Second, they've created a framework, the two-step Alice framework that the Supreme Court articulated in Alice, has become very difficult to apply by the lower courts and for practitioners to understand what the outcome would be. So a procedural framework has created a lot of confusion in the space.
So do you think that the Patent Eligibility Restoration Act would help to restore some level of predictability? Would you support this act?
Yes, I do believe that PERA fixes those issues. It addresses the substantive problem and allows Congress to actually decide after a proper legislative debate what's in and out of the patent system. And it also addresses the procedural problem, and it eliminates the confusing two-step two-step process that the courts have implemented.
Another thing,
just, if I may, very quickly on that procedural problem. One of the concerns that have emerged from the court's jurisprudence is that the courts are effectively commingling areas of patent validity.